My name is Kate Weisburd, and I'm a professor of law at UC Law San Francisco.
Well, thank you for joining us today. We're going to be talking about your article, The Carceral Home, that came out in George Washington Law University, George Washington University Law Review. And so if you could kind of walk us, before we walk anywhere, talk to us about how you came to this article and what you're thinking, how it developed over the course of this research.
Yeah, so this paper and this project was really inspired by a contradiction that I saw between the black letter sort of doctrinal law that I teach in my criminal law classes at UC Law SF and at GW where I was before, versus the reality of what I saw when I was in practice as a defense lawyer. Prior to entering academia, I represented young people in juvenile court. And so I just got a lot of experience seeing what young people go through when they're charged with crimes. So with respect to the black letter law, in criminal law classes, my students and I debate a theme that runs through a lot of Supreme Court cases, which is that the home is supreme. The physical home and private life occupy sort of an elite status in the law. The Supreme Court often refers to the home as sacred, as supreme, and as, I quote, first among equals. And so you see this sort of reverence to the home. But what I saw in practice as a defense lawyer was something very different. This sort of reverence to the home didn't exist for the young people and families that I worked with. Even if they lived in a home with four walls and a door, young people on juvenile probation, of whom I represented many, as well as their family members, were routinely excluded from this home as sanctuary idea. And the privacy protections generally afforded to people and their homes were not extended to my clients and their family members. And so sort of various methods of state control and surveillance eliminated the sanctity of their home, and their homes were transformed into what I call in this paper, the carceral home. And so that's what really inspired me, was just feeling like what I saw in practice just didn't line up with the law that I was teaching in law school. And so I wanted to unpack that and sort of better understand what this contradiction was about and how we reconcile the law in the books with the law in reality. So that's what inspired the project.
Well, that's great inspiration. Let's this question reverse. So before you define what the carceral home is, I'd like you to define what traditional systems of detention, imprisonment, and surveillance exist, and then how they factor into the carceral home. So instead of going from carceral home backwards, go forward.
Yeah, no, that's a great way of asking the question, because I think that, it's important to not lose sight of what prison is and what prison isn't. I mean, I think historically we sort of thought that people are either in prison or on probation, or they're not. And of course, that's still true. We have one of the largest per capita prison populations in the world. We have a huge number of people on probation and parole in this country. And so those are kind of the traditional means by which the state punishes and controls people who have been convicted of crimes. So people sometimes are sentenced to a prison term. People are sometimes sentenced to a prison term followed by a term of parole, which is sort of what a type of supervision that happens after prison. And then sometimes people are sentenced to a combination of prison and probation, or just probation. And probation is basically being on court supervision, meaning that you have a probation officer and a long list of rules and conditions that you have to abide by. So that's what we think of traditionally when we think of punishment and when we think of probation and parole.
Yeah, and we'll get into some of those details in a little bit, but now how does that function in the definition as you constructed of the carceral home?
Yeah, so what I did was I went back and I pulled a ton of public records, almost 200 public records governing people who are on probation and parole. And I specifically looked at what those rules did to people's private lives and their homes. Because increasingly, especially in light of the decarceration movement, more and more courts are looking for alternatives, sort of other ways other than prison to supervise and punish, to rehabilitate and punish. And so I wanted to see what these rules looked like. And so these rules are often very detailed that people have to abide by. Most often people either consent to these rules as a precondition to getting the purported benefit of not being in prison. And these rules are really interesting. And maybe I should just share a few examples of these rules because I think they sort of paint a picture of the carceral home. And, they might not seem like much on their own, but taken together, these rules really do add up and inflict, I think, significant dignitary and privacy harms on people. So perhaps most basic, in the majority of states, people on criminal court supervision are subject to suspicionless searches of their homes and phones. Many are subject also to constant 24/7 geolocation tracking through electronic GPS-equipped ankle monitors. And many of those ankle monitors are equipped with audio features that allow probation officers to speak to people on probation or listen in on what they're saying. This sort of highly sensitive private data is then routinely shared with law enforcement. Limits on physical movement are also really common for people on probation and parole. So many places people have to obtain permission to leave their home or change their daily schedule. So for example, people who are on house arrest can't leave unless they get permission. People subject to, sorry, my dog just was about to bark. People subject to electronic monitoring in Denver, for example, and I'll quote here, the rules require that the person, quote, remain inside the walls of their home and their own, quote, front yard, backyard, garage, porch, and balcony are all off limits. The Denver rules further instruct people to, quote, take out the trash on the way out to an approved activity and pick up your mail on your way home. Do not make a special trip outside to do these activities, unquote. In Mississippi, the rules governing electronic monitoring state, quote, offender has a right to work, 1 weekly church service, and medical treatment. Additional pastime is a privilege and is at the sole discretion of the agent, unquote. I'll give you just a few more examples. In other places, people are required to take the most direct route to and from various destinations. And there's also limitations on driving and transportation. So in some places, people who are on supervision can't operate a car or purchase a car without approval. It's also very common that people on supervision are subject to the warrantless collection of genetic material. So DNA samples and regular drug and alcohol tests are also really common. And again, on their own, that might not sound like much, but cumulatively, these are all very invasive surveillance methods. Interestingly, in most places, people on court supervision have to get permission to move or change jobs. There's also strict prohibitions on spending time with people with criminal records. And in many places, there are limits on spending time with family members, including your own children. In Alaska, people on GPS monitoring, for example, can't, quote, be the sole guardian, babysitter, or custodian for any person, children, or pets without approval from the EM officer. And even in some places, you can't marry or enter into intimate relationships without getting permission from authorities. So this is all, it's also very routine that people on supervision are ordered to do certain treatment programs, and intimate information such as health records, medication use, all of that is routinely shared between government agencies, private companies, the providers, and law enforcement. So these are just some examples of the way that I think criminal courts and court supervision really do transform homes and private lives into carceral spaces.
And I suppose there are two questions in this, but the first one is, so the home is being transformed, but as you said at the beginning, there's a special privilege or place in the law for the home. And also Fourth Amendment protections. Mm-hmm. What is the Supreme Court done to kind of address these issues, if anything?
Well, the Supreme Court's made it very clear in criminal procedure doctrine generally that the home is the most private, sacred space. So if you think about, there's a doctrine called the Castle Doctrine, which allows you basically to defend your home at any cost and using deadly force. And it's a pretty extensive doctrine. It has a lot of support. And there are other doctrines as well that sort of reflect this idea that the home is supreme. But those doctrines sort of are sort of siloed off and separate from the ways in which Fourth Amendment rights are very much watered down for people on probation and parole and other forms of court supervision. So, on the one hand, we have these Supreme Court cases saying that the home is supreme. And on the other hand, we have Supreme Court cases saying that people on probation and parole have fewer Fourth Amendment rights, that they aren't entitled to the same privacy protections as I am, for example. And the justification for that is that there's sort of a special government interest in supervising people who are on court supervision because of their prior court involvement and the need to monitor them for purposes of rehabilitation and public safety. Those are usually the purported justifications for this type of surveillance and this type of monitoring. So you just have these sort of two separate silos of case law. And I think what's frustrating to me as a lawyer and academic is the ways in which these silos are too siloed, right? I mean, the justification for keeping them so separate doesn't add up, in my opinion. That there's a real contradiction here.
Yeah, and I think that you addressed it, but I think there's a secondary kind of point in there that people may be hearing in their own heads as they're listening to us talking, which is, well, these people are being punished. And surveillance, as you say in your paper, perpetual surveillance is a defining aspect of prison. So if you are being punished, then shouldn't you expect some level of supervision and intrusion upon your life and some of these restrictions? So that's the first part. And then the second part is, what's the role of this new surveillance technology? I mean, when you said that some of the ankle monitors have two-way capability to talk to a parole officer, that for some reason that is scary in a whole new way. But can you speak to why some of this new technology and data collection is problematic, not just to the person being punished, but also to society in general?
Mm-hmm. Yeah, no, those are great questions. And the first question I hear you saying is a version of a question I often get, which is, say what you will about all the dignitary harms and privacy harms, but it's still better than prison. And in prison, people certainly have less constitutional rights than they do. So this seems to pale in comparison to prison. Like the carceral home is still a home. It's not the carceral prison. So kind of what are you complaining about? And I think that's a totally fair critique, but I do have an answer to it, which is that first and foremost, I think that part of the problem is that that there's this assumption that it's either prison or life on being surveilled. And I think that that is a problem because it's sort of time to recognize security as separate and apart from sort of prisons and homes. Because surveilled homes are almost always compared to prison, the baseline is the normalization of surveillance. But freedom and the right to be left alone, I think, is an equally justifiable baseline. To be free from state control and surveillance should be the guiding principle in both legal and policy reform. And part of the concern that I have with, I get this all the time is, well, it's better than prison. Well, a lot is better than prison and is still bad policy, right? That's like saying, well, the firing, like the lethal injection is better than the firing squad. I mean, sure, I guess, but isn't that a terrible, that's a pretty low baseline, and we should aim higher for coming up with policies that work. So simply because it's better than prison, in my mind, is not the answer, does not assure us that this is actually good policy that's working. There's also an assumption that anyone who's being surveilled this way would otherwise be in prison, that the alternative is prison. But that's simply not the case. Many people, I think, who are subject to surveillance wouldn't otherwise be in prison in a world without this type of surveillance. They'd be free with fewer types of surveillance. I've yet to see any empirical evidence that's convinced me that everyone who's on a monitor today would otherwise be in a prison cell if monitors didn't exist. There's just nothing showing that that's the case. Certainly some people would be. I totally concede that there are people today who are on monitors who without a monitor would otherwise be incarcerated. But that's a small fraction of everyone who is being subjected to various forms of carceral surveillance and control. So I don't buy the argument that it's a one-for-one substitution. It's also not a one-for-one substitution in terms of time. Like, it's not like it's one day of living in a carceral home versus one day in prison. More often than not, it's both, right? People spend 2 years in prison and the next 15 years of their life subject to various forms of carceral control and surveillance. So I don't think it's actually, it's almost like it's not comparing apples to apples. It really is comparing apples to oranges. And I also think it's a false premise to assume that the only two choices are surveillance or prison. And that to me feels like we're stunting our own imagination if those are the only two options. I mean, we should do better. The questions we should be asking is, do these surveillance methods work? Is this surveillance making us safer? Is this surveillance supporting people who are leaving prison? Are they able to feed their families, pay rent, hold jobs, get jobs? And if the answer is yes, then let's have that conversation about whether it's worth it. But I've yet to see empirical evidence demonstrating that, for example, requiring people to get permission to apply for a job, or, requiring people to get permission to leave their home to take their kids to school. I'm just not convinced that those types of conditions are moving the ball forward for anyone, for individuals, for society. And so, and the last thing I'll say is, you could say, well, what if it's just a form of punishment? Maybe just being subject to the carceral home is like being in a jail cell, it's punishment. That's all fine and good, but the Constitution still applies, right? It's not like the judges can just do whatever they want. In addition to the Eighth Amendment that limits, cruel and unusual punishment, there's no punishment exception to the Constitution. It's not like courts can just order that people have no more First Amendment rights, right? That they can't speak as punishment, or that they have no more Fourth Amendment rights as punishment. That's simply not the case. And in a separate article, I make this argument that there's no punishment exception to the Constitution, but courts routinely treat it as if there is.
Yeah, and I want to return to the technology thing.
Yes, because I didn't answer your second question.
That's okay, because I kind of jammed them together. But you walked right into the role of surveillance and this whole process in the courts. And I would love for you to tell us just how much court discretion there is, what the safeguards are, and if there's any overriding role of consent, because in other discussions we've had about plea bargains and how they're essential to the process, but at the same time highly problematic. So talk to us about the court discretion, consent, and what other safeguards there may be.
Yeah, so I'll start with the surveillance and sort of what the court is telling us about surveillance. I mean, I think part of the challenge is that increasingly we're getting to a point where we could have 24-hour perfect surveillance of everyone at all times. I mean, I don't think that's a dystopic view anymore, sort of even marginal, or I think that that's, more and more accepted that that's quite possible if it's not already happening. And I think that in some respects, courts are playing catch up a little bit. Like there's a little bit of a lag time between the development of Fourth Amendment law and the amount of surveillance that we have. So there's definitely a disconnect across the board. But the disconnect, I think, is even greater when we're talking about people involved in the criminal legal system, and other social welfare type, systems. There, I think that the divide between people who have privacy rights and people who don't is even greater. So to some extent, I think we're all facing diminished privacy rights. But I think that certain segments of the population are experiencing an even greater diminishment of privacy rights. And the case law isn't quite caught up. I mean, we do know that the Supreme Court has said that we have a privacy right in like our geolocation data. And so, we can't be GPS tracked, but you can be if you're in the criminal justice system, if you're involved in the criminal justice system. And there are sort of legal justifications for that. But I think there's this we're sort of increasingly coming to this sort of flashpoint of what do we do about the digital privacy rights of people who are involved in the criminal legal system, the immigration system, and other social service systems, who just by virtue of being watched more and by virtue of being able to be punished more for being watched, I think have different privacy interests than I do, quite frankly. So I do think that that's a huge issue. With respect to the question of consent, I'm so glad you asked that. And I have another paper that I'm working on right now called Criminal Procedure Without Consent, which asks what would happen if courts and police and prosecutors could not rely on consent anymore. What would happen to the criminal justice system? Well, the short answer is it would collapse probably. But the longer, more interesting answer, I think, is that consent plays a huge role in this, right? I mean, I think people are asked to consent to all of these different conditions, and it's not clear that in the absence of consent, there would be a legal basis to do all of this. So consent, I think, does the dirty work in the criminal justice system. It gets people to agree to their own subjugation. It's like subjugation by consent. And in many respects, this subjugation, this agreeing to having fewer constitutional rights entrenches the precise racial, economic, disability, and gender inequities that often inspire decarceration efforts to begin with. So that's what's sort of ironic, and not necessarily ironic. I mean, I think really notable is that these rules, the carceral home, these systems, in effect, are furthering subordination of already marginalized groups, but often in the name of decarceration.
Yeah, and I'd like to unpack that a little bit more, because I thought that was a really important point in the entire article, and really one of the crux of the it's kind of a twist of the knife, right? So you have this, whether or not we can agree it's justified to put people on some sort of surveillance for infinity for crimes they may have committed. It's another thing to have these methods and techniques of surveillance start creeping into the welfare system and the state of social safety nets. So someone in drug rehab, someone who's in drug court, someone who is on welfare, someone who has is working with child and family services, all these people are now subject to the same surveillance. How did that happen? And is it the courts that are doing it? Is it the organizations that are doing it? Is it a combination of those two with the decarceration movement? How is this bleeding over?
Yeah, so I think that it's a combination of everything that you've just mentioned. I think that it's the sort of cumulative effect of many different systems being involved in people's lives. I mean, when I represented young people in juvenile court, one of the things that I often talked about with my law students who worked with me on cases, we would often talk about how the law is all over our clients' lives in messy and intersecting ways. And it's not just the criminal legal system that's impacting them. It's oftentimes some version of, child services, child protective services, welfare, all these different systems that are housing, interacting, and making it very difficult for people to survive and thrive. And these systems all also involve a certain amount of surveillance. And so advocates and lawyers and law professors, not me, have studied, for example, the amount of surveillance in public housing and what people have to agree to in their lease to live in public housing, and the grounds by which public housing so easily can be revoked. And all of that are different forms of surveillance. And there's just been amazing research done about sort of the ways in which poor people in particular are just surveilled at such a higher level. And the stakes are so much higher. Like, even though I think we all feel a certain level of being surveilled, the stakes are so much lower for me than it was for my clients, for example.
Yes, and thank you for that, because I think that's one of the things that isn't so much accepted into the popular imagination about these programs is the amount of work and interference that the systems have in your daily life.
Right, right. I mean, another example, and another law professor who's been doing research about this, Child Protective Services often requires that in order to keep your child with you, you have to consent to searches of your home at all times. So these are just many examples, and you sort of pile that all on top, because it isn't just one system at a time involved in people's lives, it's many, and you realize the degree to which people really live under a microscope.
Right. And let's talk about some of the tools of those microscopes, because I asked the question too early, but I'd love for you to tell us some of the technology and data collection that has allowed for an expansion of the carceral system into the home and beyond.
Right. So the technology takes a lot of different forms, and it's evolving very swiftly. So initially, in terms of technology, there's a wide spectrum of technology, and I would include in that spectrum things like collection of DNA samples, drug and alcohol testing. Those are all forms of surveillance. We don't think of them as technology per se, but they certainly are surveillance methods. And then there's the more sort of traditionally technologically based methods like electronic ankle monitoring or GPS ankle tracking. Those usually take one of two forms. The first is a device. Both are devices that people are ordered to wear on their ankles. One type of device uses radio frequency to just basically alert when someone's left their home. So it's kind of like a tether to your house, if you will. And an alert goes off if you leave. So that's one type of technology. Another type that's now more commonly being used is an ankle monitor that's equipped with GPS technology that allows a state agent or private company, these are often private companies who run these programs, or at least run the technology, to monitor the location of someone 24/7 and collect that geolocation data. And then another type of technology now we see are cell phone tracking applications. So those are newer, but those also involve using a cell phone to track where someone is at all times and to communicate with people. So that's sort of probably the newest technology.
Yeah, and the listening in on conversation extends beyond. In prison you have no expectation of privacy whatsoever, but to think of having an ankle monitor and being out in public and they're able to hear everything that's going on is a little disconcerting. Right,
and GPS tracking also implicates the audio feature, implicates people around you. The tracking of your, if for example, your cell phone is being monitored or your email is being monitored, that also implicates the privacy rights of people who are communicating with you. So every text you send or email you send or receive is being read and monitored. So there's a sort of wide swath of people who are caught up in the sort of technology net beyond just the individual defendant themselves. And I should say a few things about this technology. First is that it's very opaque. We don't really know how it works. It's developed by private companies, sold by private companies, operated by private companies, and these private companies are not subject to public records laws, which means that we really don't have a sense of whether what data is being collected, how accurate these machines are. They're rarely subject to testing. We're only at the beginning of seeing litigation over this, and so we haven't seen yet a lot of litigation challenging the accuracy or reliability of some of this technology. We also don't know what data is being collected and with whom it is being shared. So there's just it feels like it's a big black box where we just don't know beyond sort of what we know from people's own experiences, which is not insignificant, but we don't know how the technology exactly operates. And so that's really hard. And I'd say it's also a gray area in terms of regulations as well. We don't have a lot of laws or state regulations governing this technology. So it's sort of, flying under the radar, if you will, of regulations. Like if you think about think about how much scrutiny goes into a hearing device, right? Before it can go on the marketplace, a hearing device is subject to a lot of testing and scrutiny, and it's continued to be monitored. We don't do any of that with respect to the use of electronic ankle monitors or even cell phone tracking applications. They're just sort of used indiscriminately. And I should say too, we don't know if it's working. Like we don't actually know if this level of surveillance is giving us what we want or hope. And in fact, there's some really convincing research that other methods are just as effective, right? So for example, in the pretrial setting, researchers just found that the use of text reminders about court dates and assistance with transportation or assistance with childcare is way more helpful in terms of people returning to court than putting an ankle monitor on them. And similarly, ankle monitors, there's little evidence that ankle monitors are leading to sort of less crime as compared to less invasive methods of support and surveillance. So I think that's the last thing I'd say about the technology is that at the end of the day, an ankle monitor is just a piece of plastic. Like it's not actually going to be doing anything to help the person on the monitor, to help society, unless that person is also being given a job and support and other forms of assistance that will help them survive and thrive.
So before we get into the policy, you touched on it right there at the end. How effective have you found this to be? And with the expansion, it seems like it always constantly is moving into more surveillance, more, control, more, and nothing ever contracts. So we never really take anything away. So how is this working? And as you said, you don't know about the ankle monitors, but like people on parole, people who are during COVID, for instance, when they were sent home instead of going to jail or prison, have we seen a decrease in crime because of this? Have we seen a decrease in recidivism?
It's very hard because it hasn't been well researched, to be honest. So we don't have great data on the effectiveness of monitoring. So I haven't yet seen studies showing that more that more surveillance leads to more public safety. Like I haven't seen that yet, at least nothing that's been convincing. There's sort of studies here and there, including studies authored by the industry, where I'm just not convinced that that is the case. Now, to be clear, I don't hate technology, and I think that technology has a place, and like even some forms of surveillance have a place in this world. And I'd be the last person to say to someone in prison today that they shouldn't ask for and get ankle monitoring if it meant getting out of prison that day. So, to some extent, I think the electronic monitoring train has left the station. It's not like we're going to stop surveillance at this point. And for people who who would genuinely, if we could figure out exactly who they were, would otherwise be incarcerated, I do think that some amount of support, I don't think it needs to be technological surveillance, it might be in order. I think the problem is that electronic ankle monitoring and other forms of court supervision that rely on technology, it's a little bit like the shiny new toy problem. It's so easy to reach for it because it seems so incredibly appealing and so instinctively better than prison. And you're exactly right. It's easy to rely on it more and more, and especially as companies further sell it as an alternative. I think we're actually going to see an increase in electronic surveillance in the Trump administration if he follows through with his efforts to deport huge numbers of people. If there aren't physical facilities to put people in, I assume that the administration is going to be relying on private companies that sell electronic ankle monitors. So we're just going to see more and more reliance on this technology in the at least in the immigration context, if not also in the criminal justice system. But we just yet don't have convincing evidence that it works better than less intrusive means. I mean, I think it's easy to say, well, monitoring works better than prison. But again, I think that that's the wrong measuring stick. I think that the right measuring stick is, well, is there something less invasive and less harmful that will still support people? And that's where I think methods such as sending text messages, helping people get transportation to and from court, helping people get jobs despite having a criminal record, all those other methods that are much less invasive and rely on sort of old school human interaction, I think are more promising and actually do have a track record of success. I mean, we do actually have a lot of empirical evidence showing that things like stable housing, stable employment, access to childcare, access to education, those things are the stabilizing forces in people's lives. It's not being subject to greater surveillance.
Right. And I think, you introduced an interesting debate between private prisons building camps to hold people versus these private ankle monitor corporations. If they're separate corporations, they may be the same ones.
They're the same.
There you go. So they're
the same.
Yeah. I would love for you to get into, because one of the things I really appreciated about your paper, because a lot of these diagnose the problems, but they don't hammer out any future policy proposals or what can be done about it. And you list quite a few of things. And you mentioned one, which is a huge one. And I think that probably is paramount. But what are some of the other ones that you lay out at the end of the paper that would help mitigate, mediate, moderate, whatever the M word is, that would this carceral creep into our private lives and homes?
Well, to some extent, I think it's inevitable that this is going to happen. So then the question is, how do we limit the inevitability? And, how do we both recognize the sort of inevitability, I think it's impossible to not have the state be in people's homes to some extent. And sometimes it's desirable, right? Like we want, for example, police maybe to investigate instances of abuse or things that happen in homes that, so I don't think that there's a world in which the state is not in people's homes. But I think that we can be more explicit and honest about how we limit and regulate the degree to which people have privacy in their own homes. So, for example, relying less on consent and instead requiring that the basis by which people have rights eliminated be some other legal basis. Like it's either allowed by law or it isn't. And we shouldn't be relying on consent to do the dirty work of the criminal justice system. It also means subjecting these forms of technology to greater scrutiny. So requiring that companies disclose how they work. Oftentimes companies use sort of trade secret laws to hide how their technology works. But given how it's being used, I think that we sort of need to pierce through that and figure out how the technology is actually working. I also think that, judges and prosecutors and defense lawyers can do more too, right? So for example, there should always be a question is there a less invasive means by which we can accomplish what we need to accomplish? In other words, does this person actually need to be in a jail cell, or does this person actually need to be on a monitor, or are there other less invasive methods of ensuring public safety, or of ensuring that they return to court, or ensuring that they get the rehabilitative services necessary? And I think to some extent it's sort of part of that is recognizing sort of privacy and personal security as entitlements that are not tied to the home, but that are tied to the individual, and that we sort of all should retain some amount of dignity and privacy interests that aren't connected to any one institution.
Yeah, and I think that is a big piece of your conclusion, and I think If you could expand on that a little bit more on the difference between the individual and how that functions, that would be, I think that's a really important point.
I mean, I think that just historically, the Supreme Court has connected the home as like sort of the anchoring force, but I think homes are increasingly amorphous. And it's not that home has no place. I mean, I think homes are really important, but I don't know if our legal rights to autonomy and privacy should be connected to our homes as much as they are connected to our individual selves and sense of self. And that freedom isn't about necessarily being free from a prison or a jail or free from a carceral home. It's about the freedom to live without state surveillance, and that should be our baseline. And that's what we should always be sort of thinking about, is ultimately that's what we all want, is to be free and able to live the life we want to live. And certainly people involved in the criminal justice system aren't going to have that same level of freedom, but that's ultimately what the goal should be for everybody at some point.
And I think that and I like that, because I think there's, at some point, if your debt to society is paid, then you should be freed from your obligation. And as we've seen throughout our conversation, that very often never happens, right?
Right, exactly.
Well, anything else you want to add about the carceral home before we wrap it up here?
I don't think so. You've really asked some great questions. I'll just say that I hope that what has come across is that the carceral home, I think, is often viewed as an alternative to incarceration, but what I hope is clear is I don't think it's an alternative to incarceration so much as an alternative form of incarceration, and that increasingly incarceration is just taking new forms, and sort of thinking about prisons as sort of brick and mortar buildings, and thinking about homes as brick and mortar buildings. I think that those defining features are sort of fading away a little bit, and the ways in which people are subjected to punishment are taking really new and different and varied approaches. And I think we need to be really aware of what those approaches are.